Hey, everybody, as you are dialing in, we're going to wait about 5 minutes. The systems can only move so fast, so we're going to try to get started at about 5 minutes after 7. So if you need to grab a drink or a Coke, we won't actually get started for another 5 minutes.
Recording in progress.
As you guys are joining, we're going to get started about 5 minutes after 8 Eastern. I'll just use Eastern Standard Time as my anchor. Got a few more people joining, so going to take a little bit longer. Okay, 7:02. We're going to wait a few more minutes. Just a couple more minutes, folks. We're going to try and start promptly at 7:05. Okay, folks, we're going to go ahead and get started. My name is John Humphrey. I'm the chairman of the Tort Claimants Committee. And we have a few new faces for those of you who have been on these town halls with us regularly. So I'll introduce those folks. And we've got a really packed night tonight. We know we have some new folks because I can look at some of the numbers. Doug's going to cover some of that in a moment, but we may go over an hour tonight. We've got a lot to cover. We're going to talk about the disclosure statement, and Deb Grassgreen, who has joined us, who's a partner at Pachulski, is going to take us through that. We've got a brief presentation to sort of give you the roadmap of what's going to happen from now. We've got an extra set of fingers on the keyboards helping to answer questions. We've received a lot of questions over the last week, so we are going to cover those in length. So I don't want to cut off the deal at 8 o'clock, in an hour, whenever that is, 9 o'clock. So if we go an hour and a half, that's what we may do. So, disclaimer for tonight: bankruptcy rules are very specific on what is called solicitation. We cannot technically solicit your vote one way or another until the disclosure statement has been sent out in the mail, either directly to you or to your attorney. And so we're not going to be doing that tonight. We're going to be talking about the process. Obviously, you all know that we object to the plan. And in the words of one of our lead counsel, it's a nothing burger for survivors. And I can tell you that I'm not going to be voting for it. So there will be time for us to tell you how we think you should vote, but that is not tonight. We think in the next few days, those documents will start going out, and then we will be very aggressive at telling you our position and why we feel that way. So tonight, would like to turn it over to Doug and remind everybody that we are recording these things. And you can go back if this is your first time and look at previous ones. And so we think we're going to be doing these every week until, at least until the disclosure hearing, perhaps maybe after Christmas. So with that, Doug, take it away.
Good evening, everyone. My name is Doug Kennedy, and I'm also a member of the Tort Claimants Committee. Like John, I'm a survivor and a volunteer as well. I want to especially welcome all of our first-time viewers tonight, and I want to give a huge, huge thank you to the attorneys that let us know that we could share information and contact their clients so that we could educate them. I have to tell you, I've been reading a lot of email today that I received. I'm the person that sent out a message yesterday about this, and I was really shocked by the number of people who said, I had no idea that these meetings were going on, that you guys existed to try and advocate for all survivors out there. There are 9 of us on the TCC, all shapes and sizes, ethnicities, ages, and all of us are volunteers. We have a group of professionals we're speaking tonight that are assisting us and advocating for all volunteers. So it breaks my heart, quite frankly, that there were attorneys out there that did not share this information. You can ask them why not, and maybe you should ask yourself why you weren't told. As I mentioned, we don't get a dime off of this work that we're doing for you tonight, John and I and the other 7 members. And we're not attorneys that are getting 30 or 40% of your settlement. So perhaps for a lot of attorneys, the reason they weren't letting you know about this was they didn't want you to listen to us. So just a reality. Having said that, we can't stress this enough, how critical it is for you to communicate with your attorney if you have one. And they are supposed to be representing you. So you need to beat on them to do that and communicate with them. And especially something that we've been saying for almost the last 18 months is if you can file a case in your state court, you need to do so or have done so. And one of the things that we found out as we went through this process is that there are some attorneys that were only representing survivors in the national bankruptcy, but missing opportunities to file claims in state court. So before the question and answer blows up with all kinds of questions about that, that's something you should talk to your lawyer to, because now is the time to make sure that that person that's taking a chunk of your settlement is really giving you the best information, making you aware of where the information is, and is representing you as best as possible. One of the other things tonight we're going to be talking about is how you'll be able to file, get a ballot and make sure that your ballot is being registered the right way. Everybody needs to take a deep breath. There's plenty of time to get your vote in on this. And as John mentioned, we're going to be having other weekly town hall meetings to talk about that process. The central hub for all of this is our website, tccbsa.com. And we're going to post this video, as John mentioned, and all our other materials on there, so you can keep checking back to there. And at the end of this video, we'll post a slide as a reminder with that website. So again, for those of you that are returners, welcome back. For those of you that are new, thank you so much for being with us tonight. And we hope you'll continue to meet with us and watch our videos. John?
Thanks, Doug. So what are we going to cover today? Well, there's a very complicated process that's before you. And what I'm most excited about, and what kind of got my sleeves rolled up about, is that your voice will finally be heard. Each one of you, whether you're represented or not, has the right to vote and has the right to tell your attorney, if they're going to vote for you, what you want to do. So I'm excited about that because, you know, many of us have lived for 30, 40 years with the pain and the shame and the what if of our abuse. And I think now we can finally be heard. And I'm hoping that we are heard loudly. So what are we going to do? We're going to go over the ballot and the process moving forward. Deb's going to actually show you what's in the packet that you're going to get. We're going to answer some key questions, not just the ones that are coming streaming in on the Q&A, but some that were sent to us to the BSA survivors at Pacholsky, pszjlaw.com. So if you don't get your question answered, and if you have another question, we'll prep those questions for next week. And we're going to do these every Thursday and try to get a pattern, unless for some reason there's no reason to meet. You're not in a hurry. By law, the BSA has to get this packet out no later than the 15th of October. It looks like it's going to start going out in the next few days. We're not completely sure. And then the deadline for your ballots to be back is December the 15th. So you have time to think about it. You have time to read these voluminous materials and consult with your attorney and let your voice be heard. We have a strategy and we have a plan, and we think that strategy and plan is going to be good for all survivors. And we're very committed to that. So with that, I'd like to turn it over to Deb Grass-Green, partner at Pacholsky, Stang, Zeal, and Jones. Deb.
Good evening, everyone. I'm Deborah Grass-Green, and I'm going to go through you a presentation about what you're going to get in the mail probably next week if you're not represented, and sometime shortly thereafter if you are represented, because your lawyer will be communicating with you. So first, I'm just going to show you, because the BSA's balloting agent sent me a sample package. So I'm going to show you what it's going to look like when it comes. So I'm going to hold it up as close as I can get. You're going to get a package in the mail. It's going to have a booklet and some pages that are in front of it. I'm going to explain to you what is here. The booklet has the plan and disclosure statement, and what you're going to see is that it's 4 pages to a page. Can everyone see how tiny it is? That may be very difficult for you to read. Even with my glasses, I can't read it. So on our website, tccbsa.com, there will be a full-size copy that you can look at also to make it easier. But let me just share my screen and go through with you some general information about what you're going to get. And then this slide deck, so don't feel like you got to take notes feverishly. This slide deck will get posted on the website, and you'll be able to download it and read it and go back to it if you have questions. So I'm going to just pull this up. Okay, so here's our presentation. So again, the website, and we'll put this up at the end also, tccbsa.com, and the email for questions is bsasurvivors@pszjlaw.com. So plan solicitation. So there was a hearing, and the way bankruptcy works is there is a disclosure statement, which is a document that describes the plan. The plan is the contract that BSA puts forward about how it's going to get out of bankruptcy. The court had to approve the disclosure statement, which is the informational packet. It's the document that I showed you. They had to approve that before you can vote. It's the information that you are supposed to read and understand so that you're informed when you make your decision whether to accept the plan or not. As John said, the package is going to be mailed in the next few days to you or to your attorney if you previously instructed that your attorney should get the documents. What's in the package? There's going to be a letter from the TCC recommending to vote to reject the plan. We've already filed that letter, and that's on file with the court, but it will be in your package. There's also going to be letters from the BSA, the Coalition and FCR, and the Unsecured Creditors Committee recommending to vote to accept the plan. Those letters have also been filed with the court. There's also a document that's called Summary and Frequently Asked Questions. This is what it looks like. That's more of a plain English document that will help you understand what's in the plan, because the plan and the disclosure statement is this giant book in tiny little print, 4 to a page, and the summary is in more plain English. Again, you get the bound book, and then you will get a ballot, and I will show you later what the ballot looks like, unless your lawyer selected what's called a master ballot method, meaning that the lawyer will communicate with you, you will tell your lawyer how to vote, and the lawyer will check it off on one ballot for all of that lawyer's clients. So what is this disclosure statement, this document you're getting? The plan talks about how your claim is going to be valued and paid, and the disclosure statement gives you information to help you decide how to vote. It's going to include background about the plan, information about proposed settlements, and it's also going to include projections about what you're going to get. Now, here's your little cheat sheet of where to go to see. The BSA has put some charts in based on what state you're in and the type of abuse you had, and that's at pages 35 to 36 of the disclosure statement. The TCC looks at it a different way. We've calculated the numbers a different way. And our chart is in pages 36 to 37. Again, you don't have to write this down. You can go look at this presentation afterwards. This is all just make it a little bit easier for you. I think I just went up a page. Sorry about that, guys. Okay, yes, next page. You're gonna get a ballot, and I'll show you what the ballot looks like at the end of this. But the ballot does 3 things. They're really important. First, the decision. Vote for the plan, accept, vote against the plan, reject. That's one decision on the ballot. Another decision is that the plan includes an option to accept a $3,500 expedited distribution. And Jim will talk a little bit about that. And you might have heard about that. You have to make that decision on your ballot. And there's information on the ballot about that. And then the third is an option for you to release directors and officers and affiliates of BSA for any claims you have against them unrelated to sex abuse claims. This is completely optional. It will not change what you get if you check this box or don't check this box. So those are the 3 things you have to do on your ballot. Okay, how do you submit it? You have to return your ballot so that they're received by December 14th. There is an electronic option. There's instructions in the ballot. The ballot is 20 pages long, by the way. There's instructions on the ballot about how to submit it electronically. You can also send it in mail, and they're going to give you a pre-addressed envelope, or you could send it by Federal Express or other overnight mail if you wanted to. If you have a lawyer and they accepted the master ballot method for you, and you should ask them if they did or not, they have to record your vote as you instruct. It's your vote, it's not their vote. You do not have to take your lawyer's recommendation. I can tell you, I've been a personal survivor in a mass tort case, not a sex abuse case, but another mass tort case, and I did not take my lawyer's recommendation. So you don't either. You can or you can't. They make a recommendation, but it's your decision. We recommend that you talk to your lawyer about it, your lawyer, not a paralegal, not someone that works in the office, your lawyer. You hired a lawyer, they have expertise, they've been trained, they should answer all your questions. You should get all your questions answered before you vote. And you should keep a record of how you instruct them to vote on your behalf. If you want to vote by yourself, if your lawyer says, I checked the master ballot and I'm going to record it for you, you can still vote yourself if you feel better with your own ballot. What you can do is you can request an individual ballot by emailing the email address that's on here, or by calling. And this email address and this number is on the ballot, but if your lawyer took the master ballot method, you might not see that on the ballot. So this will be here. It'll be posted on the website. If anybody has any questions, they can reach out to us. So that's how you
I think it's important. I think it's important for folks to know that that email and that phone number goes to Omni. They are the official agent for keeping all the confidential. That's where all your claims were processed. So it's not going to the BSA. It's not coming to us. It's going directly to the Omni agent.
That's a great point.
Yes, and we also, let me also add, we do have time. As we start to learn that people are receiving their ballots, we'll let people know. So I know everyone right now is, when am I going to get my ballot, and nervous about how soon they can get this done. Don't panic. There's plenty of time. John and I have not received our ballots yet.
Right.
Deb, I just wanted to say something, actually one or two things. December 14th is a hard deadline, folks. It's not December 15th. It's December 14th, and it's not putting it in the mail by December 14th. They have to receive it by December 14th, either through one of the three options that Deb has pointed out. So while you have a lot of time, you really do, you don't have time to do it on December 14th unless you're doing it electronically. So please, we want your voice to be heard, whichever way you vote. Don't miss the deadline. Second, you could ask your lawyer for the ballot. Now, when you get it from Omni or anyone else, we can't control that. But if you want to vote your own claim and your lawyer says, no, I'll do it for you, but you feel more in control, you can do that yourself, and your lawyer should be sending it to you. I believe there will be places where you can download the ballot if you wanted to do that, and you could fill it out yourself or use the electronic option. But I just really want to make very clear, this is a hard deadline. And Deb, why don't you go to the next page?
I'm actually going to, before we go through the plan, I'm just going to show everybody what the ballot looks like for a minute. So I'm going to stop this share, and y'all give me one moment. Okay, here is the first page of the ballot. What you can see on this page is that it tells you have to complete 4 items. We talked about the 3 decisions you have to make: to vote to accept or reject, whether you want to take the 3,500 expedited distribution, and whether you want to opt out of the third-party release, and then you have to sign it. There's going to be, I'm just going to scroll through and let you see, there's going to be a lot of explanation before you get down to where you vote, but here's where you vote. 1, the amount of the claim is already filled in at $1. It says it has a blank for debtor. I'm not exactly sure why they did that, but you can just put Boy Scouts. Here's where you check the box at the bottom, accept or reject. And again, we will post this on the website for those who don't necessarily get it in the mail so you can see it. But I just want to give you guys an idea of what you're going to get. And here's where you can elect the distribution, the 3,500 election, And then the next one is going to be where you elect the release, opt out of the release if you don't want to release the directors and officers of BSA. And then there's a whole bunch of legal explanation, which you can ask us about. If you don't have a lawyer, you can ask your lawyers about it. Then you have to sign it. You have to sign it, fill out your information. And as Jim said, here we go, look at this box. It has to be received by 4 p.m. Eastern time, or your vote will not be counted. There's explanations about how to use the e-ballot and how to send it in. So this is all on the document. We'll put it on our website, but I just wanted you all to have an idea of what you're looking at and what you expect to get. So I'm gonna go back to the other-
not like your taxes of postmarked. It has to be in their hands.
Okay, so let's go back, Jim. So
Okay.
Jim's going to talk a little bit about the plan next.
So we're going to have many more of these town halls about the substance of the plan. But I wanted to talk for a moment about the $3,500 election. And also, because I know some people are thinking to themselves, how could I possibly be paid only $3,500 for the abuse I suffered? So I want to give you kind of the background of that. And I also wanted to chat for a moment about the messaging that's going out that the TCC doesn't know how to say anything except no. So let's first start with the $3,500. When you go to the chart, and I'm basing this on the settlements that currently exist, and we'll talk about the potential for future settlements in a moment. But if you go to the charts that Deb identified that are in the disclosure statement, there are people who, depending on the nature of the abuse you suffered and the state in which the abuse occurred, that's the statute of limitations discount, based on existing settlements, will not get $3,500. And if you just went through the process, thank you, Deb, there's the chart. You'll see it's on page 37 of the disclosure statement. And I'm not going to get into a lot of detail about what all these columns and rows mean. We will do that in another town hall. But the top level of abuse, which is penetration, which is the top of this page, if you are in what we call a closed state, which is pretty much a consensual agreement amongst the professionals that your statute of limitations is extremely restrictive, if not entirely shutting you down, you would get from existing settlements approximately not quite $3,200. Now, that's kind of a no-brainer for the $3,500 election. And as you go through the other levels of abuse and you look at the other states or categories where the abuse occurred, you'll see the $3,500 makes sense for some people. To get the $3,500, which, by the way, is an option the TCC does support, and I dare say was the option the TCC came up with, you have to personally sign your claim form, not your lawyer, but you personally have to sign it under penalty of perjury, and you have to substantially complete it. So we have looked, eyeballed every single claim in this case. And some of you did a really thorough job of filling them out, and some of you didn't. And when I say you or your attorney. So those are the two conditions. You sign it yourself and it be substantially completed. So something that I believe it was Doug said at the last town hall, we are not the party of no, we are the party of more. The settlements that are in the existing plan are woefully too low. They do not represent, in our opinion, the true value of claims. They do not represent the amount of risk that Hartford Insurance Company has for the claims in its years, which are over 24,000 claims. We do not believe it reflects the fair value of the settlement by the Church of Latter-day Saints. And so it's not that we're not interested in settling. We are willing to settle because we understand the time, the cost, and the loss that all of you have suffered and are suffering. But we are not going to be part of a settlement that shortchanges you. That we're just not going to. At a hearing about, I think it feels like forever ago, but it was probably not more than 10 days ago, one of the state court lawyers challenged the TCC, challenged the members of the TCC themselves, that they had no solution other than to say no. I have to tell you that working with Doug and John and the other 7 men for the last year and a half, I could feel their pain. It was insulting. So I had a moment to respond to that. And I pointed to one of the insurance company lawyers and I said, "You want me to make a deal with him? I'll make a deal with him in 5 minutes. All I have to do is accept his number. Hell, I can make a deal with anybody if I accept what they've offered." The purpose of my firm's representation of the TCC and the TCC's purpose in being a fiduciary to all of you, it's not to accept the lowball number. It's to get the parties up so that the compensation is at least fair. And I said at the end of my short statement, in a race to the bottom, I can run faster than anybody. But that is not what we are interested in. We are not interested in a race to the bottom. What we're interested in is a fair settlement for all of you, understanding the pressures you're under, the needs that you have. Because as John said, the 9 guys on the committee, they're like a cross section. Age, ethnicity, income, family backgrounds, they are truly representative of everyone in this case. And they are acting not out of their personal self-interest. You've heard them say it, it's true. They don't get a dime. They haven't gotten a free dinner out of this because of Zoom. And they are doing this because they care. And they are what the lawyers will call fiduciaries to all of you and not acting in their self-interest. There will be no deal that gives Doug Kennedy a dime more as a percentage based on his claim than anybody else. So that's the story of the $3,500. And that is the story of why we think these settlements are too low. And we will go into more detail in future town halls. We'll walk you through the claims. We'll walk you through the valuations. But this is the motivation of this committee, to get you a fair deal. And we don't think this plan, in the TCC's opinion, and we've expressed this on the record, we've said this in public in front of the court, these deals are not that. So Deb, go ahead.
Where are we on our presentation, Deb? Are we ready to, you're muted. We ready to go to Q&A or?
We're ready for Jim to talk about plan comments. So Jim, can you see page 6 of the slides?
I see the slide. You want to talk about plan treatment?
Just,
Okay.
So tonight we're just going to go through some really high level points about the plan. As Jim said, we're going to break the plan down into little pieces. Each week, we're going to take another piece. We're going to go through the chart slowly. This is kind of the introductory overview. We've got a couple slides for you just to highlight things.
So the plan creates something called the settlement trust. That is where the money will go and the property will go to pay your claims. So because that's where the property is, that's where your claims go. So your claims, if the plan is confirmed, will not be any longer against the BSA. And depending on the settlements, against some of the settling parties, like the local councils, they will be channeled, transferred to the settlement trust. That's where you will look for the payment of your claim. The property that's transferred to the trust, I'm sorry, we'll get to that in a moment. So then it's practically none of you, I dare say none of you, have a dollar amount that a court has established regarding your claim. No one is holding a judgment that says, I'm owed by the Boy Scouts $1.2 million. So we have to figure out a way to divide up the money that's in the trust. And the way that is done is what we call a chart of values. Some people call it a matrix. And I'm not going to ask Deb to put that back up, but that chart we had a few minutes ago, those are the tiers of abuse: penetration, masturbation. There are a couple of other categories. And we start with an assumption, and I'll use penetration as an example, that the penetration claim is worth $600,000. How did we come up with $600,000? We sat with people, lawyers, who have literally hundreds of years collectively of experience of litigating against the Boy Scouts and other institutions responsible for hurting children. And then he said, okay, we got lots of different places in the country. We're trying to do this in a uniform way to at least for start value. What do you think we should start at? And the decision was made. It's a recommendation. It's in the plan. It's not binding on you until the plan's confirmed, that the starting point for valuing your penetration claim is $600,000. But we also recognize that these claims can be of much greater value. And so we put a maximum value on it. Why should there be a maximum? Well, frankly, you can break the bank. You can break the settlement trust. And we want to be sure, to paraphrase someone else, that no claimant is left behind. Incidentally, we think these settlements leave a lot of people behind. Just look at that chart. That's why we think these settlements are too low. But there is a maximum that you did for the value of your claim. All right, I got a $600,000 penetration claim, but that bastard abused me for 3 years straight. 600 grand, does it get to go up because of the severity, the frequency of the abuse? And the answer is yes, it can. There are things called scaling factors. These are in the plan. They are in what are called the trust distribution procedures. And again, the lawyers who've got vast experience of actually litigating against the Boy Scouts, actually going to trial against the Boy Scouts, came up with various categories of things that happened to you that would increase the base. But unfortunately, there are also legal reasons for why the claim could be worth less than the base. And the one that stands out in most people's minds is the statute of limitations. Every state has its own statute. Some states have statutes that are similar. So we created baskets of states. So in that chart, when you go back and look at it, it says open. That means that there is no statute of limitations in the state, at least at the time that your claim was filed. Some of you are young enough that you're within the statute of limitations, even in a tough state, but that's still counted as open. And then there are the states where, sadly, you just shut down. And if you're too old, your claim will not survive in the court. We call those the closed states. And in between are what we call the gray area. And we even took that into separate categories, category 1, category 2, category 3. And the plan has a chart that shows you the different discount values depending on what state you were abused in. Now, I know people think that statute of limitations are unfair. They are unfair. They're not for plaintiffs, folks. They are for defendants, but they exist. And so they are part of the scaling factors that can take your claim down. Because at the end of the day, when we talk to insurance companies, when we talk to the Mormons, when we talk to other chartered organizations, we talk to local councils, their answer is, I'm not putting up that much money. You sue me in court, I'm going to get it tossed on the statute. I mean, they're that blunt about it. They are that uncaring about it. So when we try to figure out where the money's coming from and try to figure out how to fairly distribute it, the statute of limitations becomes a factor. So Deb, we can go to the next.
So I'm going to kind of hijack it. I think it's time for us to get to some of the questions because we're 20 minutes to the hour. I think this timeline is important, so maybe we cover that, Deb, and then we'll go to questions.
Sure. Just again, we'll post this, but just so all of you see and everybody remembers. So the packages are going to get mailed to survivors who do not have lawyers no later than October 15th. If you have a lawyer and they elected to send the packages themselves, they'll get the package and there may be a few days delay by the time they get it to you. On November 30th, some additional information, such as the folks that are going to be running the trust will be identified. 12/14, ballots must be received, hard deadline. 12/21, that's when we're going to have the first view of how the vote came out. And I've seen a couple questions here about, well, can't the plan get confirmed even if we vote no? If the survivor class votes no, then the channeling injunction, which is a condition to all these settlements that gives the releases to the local councils and the releases to the insurance companies, can't be approved if the survivor class votes no. So I did see that question and wanted to answer it. And then the court's going to start the confirmation hearing on January 24th. Independent of how everybody votes, the judge has to find that the plan meets the requirements in the bankruptcy code to be confirmed. And there's lots of objections that have been thrown out there by various parties. So that's probably at least a week-long hearing. So that's the timeline. Again, we will post this and let's go on to questions.
Great. Thanks, Deb. Jim, you might have already covered this, but I want to get another shot out on it because, you know, the TCC has sort of been accused of accomplishing nothing. And, you know, the other side has put 1.7 billion on the table. What does that say about us?
Well, first of all, people take credit for things that they shouldn't be taking credit for. We've participated as mediation parties in all these cases, and I can't discuss the details of it, but I can assure you that even the numbers that you're seeing are the result of the upward pressure that the TCC has tried to assert. But you know, let's just be really straight about this. If I demand from someone $100 and someone else who claims to be more important in the case says, I'll take $70, who do you think the insurance carrier is going to talk to? This isn't going to be the person asking for $100. It's going to be the person asking for $70. And so we have done, in the circumstances that exist with other people representing survivors, to put upward pressure on these numbers. But like I said, you don't talk to the person who demands the most of you. You talk to the person who demands the least of you.
So how would you respond to the question that we've been completely unrealistic in our demands?
Well, we'll work through, well, I don't know, ask the person who was sodomized whether $600,000 is a fair number for what they experienced, and I'll run the numbers out at another town hall and tell you how many people have asserted that, which forms the basis for our demands. Yeah. Folks, you just do some of the math and take that settlement number. If you want to use averages, which are just averages, and divide it by 82,200 people, and you tell me, congratulations, you got a claim worth $600,000. Look at how much you're getting.
Yeah, and one thing to add to that, John and Doug and everybody, is that our demands are based on facts. Our demands are by looking at the claims and our demands are also based on the amount of available insurance out there. We're not picking a number out of thin air and saying, wow, this is a big number, this looks good. We're looking at the claims on the one hand, and then our insurance advisors are looking at the insurance policies and saying, hey, there's insurance that's available on the four corners of this document to cover those claims. And so we're not telling an insurance carrier, hey, you got to pay us $500, even though your policy only covers a $100 claim. The policies cover the amount of money that we're demanding. And I think there's just a matter of impatience on the mass tort side with the mass tort bar of them wanting to get paid first and sooner before we can negotiate a reasonable settlement that's meaningful for survivors.
John, I'll just add one other thing. I know we're keeping an eye on the time here and people's patience is limited. We did, as the TCC, an analysis of every single local council. We appraised over 500 pieces of property. We can tell you, and we will be able to tell you soon, because there's levels of confidentiality, but we're getting there so you can see this yourself, how much each local council has in cash, how much each local council has in real estate, whether those properties are subject to donation limitations by the people who contributed the money. We can show you how much they have per scout, how much they need per scout. There's a big difference between that. And we can show you where their real estate is and how many camps there are within a 5-mile radius, 10-mile radius that are surplus. And we come to the conclusion that the amount being paid by the local councils is way too low. And by the way, you'll hear that they're putting up $600 million. That's not true, folks. They're putting up $500 million of cash and property and a hope note that depends on how the pension plan performs. Now, we all hope the pension plan performs really well because that extra money will go to survivors. But let's be real about what is on the table.
Let me make a comment and then ask a question. One of the comments I want to make is I hope people are seeing the reason why we selected Jim and John and Deb's firm to represent us. They've been in the bankruptcy business for decades, and specifically representing people that are survivors of sexual abuse. They understand this territory, and they've got a track record with all kinds of organizations. You're probably also starting to see the reason why, and as John Humphrey mentioned, we can't tell you how to vote, but we can frankly tell you this plan sucks. And I think that's not the legal term, that's the survivor term. It sucks. My question for Jim then, though, is I'm reading some of the questions and people say, so if we vote this down, what happens then? Are survivors going to have to wait years? And what leverage does the TCC have at that point?
Well, I'll give you an example, a real world example of something that happened when a plan was denied. And I was not the attorney for the survivors in the case. The Archdiocese of Minneapolis-St. Paul had a plan go out that was endorsed by the Archdiocese and a plan that was supported by survivors. That's not the situation here. The only plan that's going out right now is the one supported by the BSA and the Coalition and the Future Claims Road. Neither plan in Minneapolis got approved. The court said, go back to mediation and get it right this time. Get something that's acceptable to everybody. So if this plan is voted down and we don't have our plan available because of certain procedural issues for you to vote on, I suspect the court will say, go back and get it right this time. Now, you have insurers who want out and never want to hear the phrase Boy Scouts again. You have local councils who really do know. By the way, that evaluation I talked about of each council, each of them has it. The Boy Scouts sent each one of them that information. They know how much they've got left in their pockets. And you go back and you take another shot at it. And if we can't reach a resolution, we will ask the court to allow you to vote on our plan, which I cannot describe tonight because you don't have your plan and disclosure statement in your hands yet. And see if that sits more favorably with you.
Jim, it's the law of large numbers. And I guess the thing I want to encourage people is to not get overwhelmed by this billions number because there's 82,500 of you. It's completely unprecedented, a class of this size across so many different jurisdictions. So one of the comments that led to this question was, if there's 1.7 billion, didn't one of the coalition attorneys state that they thought they could double that amount, before confirmation and even after? How do you respond to that?
Well, I don't know, counting chickens before they hatch immediately comes to mind.
And should we be impressed that that's a lot of money?
Well, I wish I had $1.7 billion, but I wouldn't want to share it with 82,000 of my relatives because I probably couldn't afford lunch at McDonald's. It's counting your chickens before they hatch.
Yeah.
I mean, God bless the person that can take that 1.7 and multiply it times 10. But frankly, they don't have those settlements in hand. There is no guarantee that they will be in hand. All that litigation they say that they're laying at our feet, all you guys want to do is litigate and it'll be years and years. That may be true for them too. And so those values that you're hearing about are just values of your claims. They're not dollars in your pocket. And honestly, if again, using averages and discounting for the Mormon money, which is by the Mormons, dedicated only to Mormon survivors, wasn't anyone's choice but theirs, and taking off the costs of the trustee, which will not be insignificant. $1.4 billion just doesn't go as far as it used to. And I'm being a little sarcastic about that. Well, very sarcastic about that. But there are 82,000 people who need to be compensated. And that sum is just not enough.
So interesting question here about sort of how the trust is going to work, and a question around how the settlement trustee makes awards that are binding on the carriers.
Well, he doesn't. I've never attended town halls other than the ones we have sponsored. But I've been told that the message was this trust distribution procedure, the way of getting a value of your claim outside of actually going to court, which will be run by the settlement trustee. You put the information in, the computer whirs, it whistles, and out comes a number at the end. And that number must be paid by the insurance companies. Well, legally, that's just not correct. It doesn't have to be paid by the insurance companies. Second, I don't even think that people who presented that scenario even believed it themselves or believe it today. And so what you're going to get out of this TDP process, in my opinion, is a number that you can then put to the insurance carrier and say, this is fair, this is reasonable, you should pay it. And there'll be possibly a negotiation over that. Now, you can do that on a case-by-case basis. You can take 10,000 people and present it in one big bill, if you will. But that TDP process, if you're talking to any insurance carrier in this case, they will say to you that that number that comes out of the machine at the end is not binding on us.
Yeah. And there's something else important to point out too. The BSA, the coalition, and the future claimants representative are all rushing to settle with insurance companies like they've tried to do with Hartford. And Century could be next, AIG could be after that. But once they settle with them, there's no more going to those insurance carriers to get any more money because they've ridden off into the sunset. And so the trust will have what money it has from Hartford or Century or AIG or Liberty Mutual or whoever it is. And so regardless of what the trustee can do or not do, if they settle with the insurance carriers, they're done. So,
Yeah, so there's two questions that sort of fall into that category, and I'll try to paraphrase them so that you can answer them both sort of in the same breath. Is the failure of the plan a nightmare scenario in which victims will wait years to see a penny? And what leverage will the TCC gain if a plan is voted down?
Well, I just want to just go back to something John said for a moment, which is absolutely true. People, this idea that you pay the number, the insurance company pays the number that is produced from this process, it's only true if they haven't settled. So Hartford doesn't care what number comes out of that machine. Hartford's gonna, if the plan's approved, will pay $785 some odd million, and they've ridden off into the sunset. And if the total Hartford claims are valued at $1.2 billion through this TDP process, no one's going back to Hartford to ask them for the difference. You're locked in. That's the number. They're gone. They've erased the Boy Scouts from their memory banks. So, nightmare scenario. Frankly, I think this is a nightmare scenario. If the plan is voted down, the judge will articulate why. Well, if the plan is voted down, the plan is voted down. But there are a host of other things the court has to consider and that the court will opine about. And you listen and you learn from what the judge has said. You consider whether she's right or wrong. And you go back to the negotiation table, because if we're able to establish that Hartford's claims are worth a significant more than what they're paying, and that their defenses for why they don't have to pay are not legally strong, they will pay more. Or they will face, honestly, they will face lawsuits around the country from people who were abused during the years that Hartford wrote the insurance. And at some point, Hartford will come back. Hartford will come back and go, I can't take, can't take this anymore. So is there a scenario where there could be litigation in the future? Yes. And what we are trying to do is evaluate the cost of that, what it imposes upon you folks as individual claimants, and what to do for the group as a whole. But we just don't think these numbers cut it.
John, Lucas, I have a question for you. We're with voting about to commence in a big way. Do you have any concerns about any sort of fraud or the court really knowing who voted and us being comfortable with the results?
So a couple points on that. In any bankruptcy case, anybody can file a claim. And so there are a lot of claims here, over 82,000. And I imagine that there are some claims that probably aren't valid here. I don't think that there are a substantial number of those. And we believe all the people that have filed claims. And there might be a few bad apples out there that have filed some claims that aren't valid. And so be it. But I don't think it's enough to move the needle one way or the other. But what I think is most important, and Jim and Deborah had touched on this earlier, is one of two things. If you're doing this by yourself and you get your ballot, make sure that you've read everything and you mark your ballot on the decision that you want to make, and you get it to Omni so it's in their hands by December 14th. That's point number one. If you're represented by an attorney and he or she is going to be using a master ballot, then it is imperative that you talk with your attorney, get advice from your attorney so that you can make an informed decision. It's your decision. It's not your attorney's decision. And you need to send a message to your attorney in writing by email, for example, so that you can preserve the message and say, I want to vote to accept or I want to vote to reject. And so that is what is going to make things matter, is making sure this is your time for your voice to come out. And I think that, that's the biggest thing that I have a concern about, is making sure that survivors are in communication with their attorneys, and those who don't have attorneys are able to review the materials and get their ballot submitted to Omni so that it's in Omni's hands by December 14th.
So folks, it's almost 9 o'clock on the East Coast. I'm going to let it run a little bit long tonight. I've got a couple of more questions that I think are important, and then we'll move to try to wrap up. We'll be no more than 10 or 15 minutes. The next two questions were about the BSA specifically. One was related to their cry of running out of money, and is this sort of the boy that cried wolf? And then there's a question about the BSA Chapter 7. Is that even possible?
Okay. So BSA's contribution to the settlement trust consists of a couple of different things. It consists of the Norman Rock, an art collection, a lot of Norman Rockwells, oil and gas interests that presumably they were donated to them, some real estate and cash. Bankruptcy is expensive, folks. And that is one of the things we factor in, by the way, when we're talking about whether or not we support a plan. And under the agreement with the, and by the way, we've scrubbed BSA's National's financial condition. We looked at their trusts, we looked at their endowments, we looked at what they said was restricted by people who made contributions, saying it can only be used for Camp Runamuck. And we concluded that the settlement with the Boy Scouts, not the local councils, not the charters, not the insurance companies, was something we could get behind. The cash portion of that decreases as the expenses continue. The Boy Scouts, from an operational perspective, so what's shrinking is the cash going to the trust. And as I said, we're watching that like hawks, and it's part of our consideration on how to respond to what's going on in the case. Operationally, the Boy Scouts have all this other money. And that, based on our financial advisors' projections, is more than sufficient for the Boy Scouts to continue operating. Now, why did we leave money on the table? Some of that money is restricted. Some of it is in places that would be extremely difficult to get to because of the way where the money's been deposited in trusts or endowments. And the judge said something months and months ago, that it was important for the Boy Scouts to emerge as a stable entity. And so when we negotiated with the Boy Scouts about their contribution, we kept that in mind. And so is there money left on the table for the Boy Scouts to operate? Yes, there is. But the Boy Scouts are not, their checks are not going to start bouncing. When they talk about the money shrinking, it's not the money they have to operate. As to Chapter 7, Chapter 7 is Chapter 7 of the Bankruptcy Code. It is the provision that calls for the liquidation of the company that files bankruptcy. It has a mandatory trustee appointed, automatically appointed. Under the Bankruptcy Code, entities that are, the code uses the word not moneyed. Some people translate that into nonprofit. So I'm going to use the term nonprofit. That nonprofit entities cannot be forced into a Chapter 7. If this were your run-of-the-mill company and it was not getting the support of creditors for a plan, or it was running out of operating cash, the court could convert the case to a Chapter 7. That is not possible with a nonprofit entity like the BSA, or with an entity like the BSA. BSA could voluntarily go into a Chapter 7, but its board would go away and a bankruptcy trustee would be appointed. If it's really, bankruptcy trustee would be appointed. A BSA could dismiss the bankruptcy case and go back to the day before it ever filed. But it can't be forced over its objection into a Chapter 7.
Okay, thanks, Jim.
I have one question. Have we discussed at all what the vote split has to be, how that works, how many people have to vote to accept or reject?
Way to go, Doug. I was just going there. So
Okay.
Go ahead. Take it away.
So creditors under a plan are divided into classes. The people who provided the patches and the uniforms, they're in a class of creditors separate from the class of abuse survivors. The bankruptcy rule applicable to the class of abuse survivors is that 66% of those people who vote, okay, not the 82,000 and change, but the people who vote, 66% of them must vote yes in order for the court to confirm the plan for the Boy Scouts. Now, as you know, this plan has a lot of people hanging on to the Boy Scouts coattails. We got local councils who are looking for relief from your claims because of their relationship with the Boy Scouts, but they're not in bankruptcy. Not a single local council is in bankruptcy. So because they haven't paid suffered the pain, paid the price, whatever you want to call it, as being in bankruptcy, the court will require a higher yes vote to extend these extraordinary protections to the local councils. How much more than 66% is debatable. If this were an asbestos company, by statute, it has to be at least 75% of the people voting. So I think a lot of lawyers think that 75% is the floor in a case like this, although that's just, yeah, that was an asbestos case number, but people use it for guidance. There are some courts that require an acceptance as high as 90%. So one of the things Judge Silverstein's going to have to do is, if this plan beats the 66%, she's going to have to decide whether the additional percentage points, the additional people over the 66%, represent enough people saying yes to extend to the local councils and the chartered organizations the extraordinary protections that this plan is offering. So bottom line, 2/3 minimum. How much do you have to have for the extras? Not clear.
Okay. I think I'm going to start trying to wrap it up, if that's okay with all you guys.
Hey, John, before you do, I wanted to say a couple of things, because there are literally hundreds of questions in the Q&A, and me and the other members on the Pachulski team are doing our best to answer them. But probably the number one question that we're getting is, what are the statute of limitations for the claims that I have? I was abused in New Mexico, or I was abused in Ohio, or I was abused in New York. I'm just picking, things. How is that going to affect my claim? And how is the claim going to be determined? We're not going to get into those details today, but I will tell everybody here today that we will have a town hall that discusses statute of limitations and the TDP on sort of a high level. And so it is the number one question. And so I apologize if I wasn't able to get to your questions, answer some of your questions on that today, but the stuff on statute of limitations and sort of how claims are calculated under the trust distribution procedures, which we call the TDP, will be at a future meeting, and we will advertise it as such. Just look at the website, www.tccbsa.com, and for a date and a time. Thanks, John.
Thanks, John. So you guys know, if you've been on these before, we are a passionate lot. And so the question is, what are we doing today and where are we going? We're resetting our purpose, and that is to object and to try to put pressure on the other parties to come to the table with a little more meaningful approach. We're going to do these town halls every Thursday night, and the format is going to be, we're going to pick a topic. So we sort of breezed over a whole lot of topics, but it might just be on the best way to fill out your ballot. What's the fine print say? It might be, how does statute of limitations work? It might be, what is the governance of the trust and why should you care? There's just a whole host of topics that we're going to be covering, and we're going to be getting to that in the coming weeks. So Doug, you want to just cover high level what we want? I mean, I think a lot of times people think we just want the Boy Scouts to go away. And
right. Yeah, I think it's worth reiterating, John and I are survivors, and we want some degree of resolution as well. We don't want this to go on forever, but we're really cognizant of the fact that when there is a settlement someday, that's it. As John said, you can't go back, Jim said, you can't go back to the insurance companies. The future of the Boy Scouts is not the concern of the TCCs. We've said that from the very beginning. It's their bankruptcy. What they do in the future is their business. What we want is an appropriate settlement from them. And we think that there is going to be an appropriate amount of money if it increases, especially with the local councils. The local council contributions are ridiculously low. And as we've alluded to, we're under a little bit of restriction as to what we can talk about, but we're working very hard. The attorneys are working very hard to be able to share more of that information. We also want an appropriate settlement with the insurance companies. The settlements thus far are ridiculously low. And a number of the questions alluded to the fact that, yes, all of us help pay those premiums. You know, we paid those premiums through our dues and the uniforms we bought and all the money that we spent. So it's time for them to pay back now. And we know what the exposure is, and it's a lot more than the settlement numbers that are being talked about. So what we want, as Jim said, is we're not the party of no, we're the party of more. And we think we deserve it. And we're hoping the media is going to start to scream that loud like we are. And there's increasing coverage about that. And hopefully through people's votes. And again, we can't tell you how to vote for this plan that sucks. But next week, we'll be having a lot more specific discussion.
How we really
about
feel.
that. Yeah.
Yeah. So as we wrap up, remember tccbsa.com. Remember BSA survivors at pszjlaw.com. And, you know, I just want to end on a personal note and just tell you how I feel about this plan that's being put forth. You know, you've heard me tell my story. You know that I was pervasively abused for over 200 times in a 2-year period. And that my abuser had complete and total control over my life for a long, long time. And I just refuse today to allow him to have that power and that control. And I refuse to go back to feeling like a victim again. And so for me, you're going to hear lots of reasons from our attorneys on why this plan needs improvement. But for me, it's very simple. There's 3 things. The monetary side is just way too low. The Boy Scouts got themselves in a pickle when they did that deal with Hartford, and they can't get out of that pickle unless the plan is voted down. The coalition are mostly mass tort lawyers. They've got lots of bills. They tend to make a lot of money in commission. They're in a race to the bottom. And the local councils, as Doug said, we will show you documentation that says they could maybe come up with 3 times what they've got right now and not affect their operation or their credit rating. But most important, I think, to some of us is we don't ever want this to happen again. And so we're extraordinarily focused on these non-monetary issues. I mean, do you realize out of the 82,000 claimants, 18,000 happened after the Boy Scouts Youth Protection Program was put in place? And we just think that's woefully inadequate. There is no oversight. Their plan waters down what happens to the IV files and how all of that stuff is treated. And we're going to hold their feet to the fire. We think that is really, really important. And then the last thing, it bothers the heck out of me, is the way this trust is going to be governed. It's not clear to me that it's just not going to consume a shitload of the cash that gets put in it. I'm not a big fan about how the governance is structured or who they've selected to put in there. And so we're going to have a lot to say about that. But those 3 things, non-monetaries, the monetaries, and the governance, that's what's personal to me. And that's why I'm going to object. So with that, I want to wish you all the best. I want to wish you guys hope, talk to people, find a friend. Let's share these town halls with people so that we can all get a little more educated. Good night, everybody.
And all the town halls will be on this same Zoom link and same dial-in, however you're getting in. And so the date and time will be there, found at www.tccbsa.com. If you have any questions, please send your questions to that email address right there, bsasurvivors@pszjlaw.com.
Same bat time, same bat channel.
We're going to try to do this once a week, everybody. Spread the
everybody.
word.
All right. Thanks.